We're returning to Frederick, Colorado, where you can see Christopher Watts is in court for his arraignment. Faces multiple murder charges in connection to the deaths of his family. 5 counts, in fact. Let's take a listen.
Or consult with a public defender before any further proceedings are held, and I see that you've taken advantage of that right. Any plea that you make must be made voluntarily and not the result of undue influence or coercion. You understand? Yes. At this point, I have denied your right to bail, given the charges. You can certainly have a conversation shortly about that issue. You have the right to understand the nature of the charges. We'll go over them in a moment. You have the right to a jury trial. You also have the right to demand and receive a preliminary hearing within a reasonable time to determine whether probable cause exists to believe that the offenses charged were committed by you. Do you understand? Yes, sir. I assume that the defense has received a copy of the complaint and information. Mr. Watts will explain to you what you have been formally charged with and what the possible penalties are. Count 1 alleges that on or about August 13, 2018, Christopher Lee Watts unlawfully, feloniously, after deliberation, and with the intent to cause the death of a person other than himself, caused the death of Shanna Watts in violation of Colorado Revised Statutes 18-3-102, subsection 1, subsection 8, and that crime is classified as murder in the first degree, a class 1 felony. Do you understand? Count 2 alleges murder in the first degree, also a class 1 felony, and it reads that between and including August 12, 2018 and August 13, 2018, Christopher Lee Watts unlawfully, feloniously, after deliberation, and with the intent to cause the death of a person other than himself, caused the death of Bella Watts in violation of Colorado Revised Statutes 18-3-102, subsection 1, subsection 8. Do you understand? Yes, sir. Count 3 alleges murder in the first degree, a class 1 felony, and specifically it alleges that between and including August 12, 2018 and August 13, 2018, Christopher Lee Watts unlawfully, feloniously, after deliberation, and with the intent to cause the death of a person other than himself, caused the death of Celeste Watts in violation of Colorado Revised Statutes 18-3-102, subsection 1, subsection 8. Do you understand? Yes. Count 4 alleges murder in the first degree, a class 1 felony. It alleges that between and including August 12, 2018 and August 13, 2018, Christopher Lee Watts unlawfully, feloniously, and knowingly caused the death of Bella Watts, a child who had not yet attained 12 years of age, and the defendant was in the position of trust with respect to the victim in violation of Colorado Revised Statutes 18-3-102, subsection 1, subsection F. Do you understand? Yes, sir. Count 5 alleges murder in the first degree, a class 1 felony. It alleges that between and including August 12, 2018, August 13, 2018, Christopher Lee Watts unlawfully, feloniously, and knowingly caused the death of Celeste Watts, a child who had not yet attained 12 years of age, and the defendant was in a position of trust with respect to the victim in violation of Colorado Revised Statutes 18-3-102, subsection 1, subsection F. Do you understand? Yes, sir. With regard to these first 5 counts, the minimum sentence that the court could impose if convicted is life imprisonment in the Colorado Department of Corrections, and the maximum death, the sentence is death. Do you understand? Yes, sir. Let me also point out that pursuant to Rule 32.1 of the Rules of Criminal Procedure, the prosecutor would have to file a written statement of intent to seek the death penalty no later than 63 days after arraignment. Do you understand? If a life imprisonment sentence was imposed, it would be without the possibility of parole. Do you understand that? Yes, sir. Count 6 alleges a Class 2 felony of unlawful termination of pregnancy in the first degree, Specifically, it alleges that on or about August 13, 2018, Christopher Lee Watts, with the intent to terminate unlawfully the pregnancy of a woman, namely Jeanette Watts, feloniously and unlawfully terminated the pregnancy of the woman. Further, the woman died as a result of the unlawful termination of the pregnancy in violation of Colorado Revised Statutes 18-3.5-103. Do you understand?
Yes, sir.
The possible penalties, if convicted for this crime, is a mandatory minimum 16 years in prison up to 48 years in prison, followed by an additional mandatory parole period of 5 years. Do you understand?
Yes, sir.
Count 7 alleges tampering with a deceased human body, a Class 3 felony. It alleges that on or about August 13, 2018, Christopher Lee Watts, believing that an official proceeding was pending, in progress, or about to be instituted, and acting without legal right or authority, unlawfully and feloniously, willfully destroyed, mutilated, concealed, removed, or altered a human body, part of a human body, or human remains with the intent to impair it or their appearance or availability in the official proceedings in violation of Colorado Revised Statutes 18-8-610.5. Do you understand?
Yes, sir.
Count 8 alleges also tampering with a deceased human body, a Class 3 felony. It alleges that on or about August 13, 2018, Christopher Lee Watts, believing that an official proceeding was pending, in progress, or about to be instituted, and acting without legal right or authority, unlawfully and feloniously, willfully destroyed, mutilated, concealed, removed, or altered a human body, part of a human body, or human remains with the intent to impair its or their appearance or availability in the official proceeding in violation of Colorado Revised Statutes 18-8-610.5. Do you understand?
Yes, sir.
And finally, count 9 alleges tampering with a deceased human body, a Class 3 felony. It alleges that on or about August 13, 2018, Christopher Lee Watts, believing that an official proceeding was pending, in progress, or about to be instituted, and acting without legal right or authority, unlawfully and feloniously, willfully destroyed, mutilated, concealed, removed, or altered a human body, part of a human body, or human remains with the intent to impair its or their appearance or availability in the official proceeding in violation of Colorado Revised Statutes 18-8-610.5. With regard to counts 7, 8, and 9, those Class 3 felonies carry a presumptive range of 4 to 12 years in the Colorado Department of Corrections. If there were sufficient mitigating circumstances, the minimum could be as low as 2 years. If there were sufficient aggravating circumstances, as many as 24 years. And any prison sentence would be followed by an additional mandatory parole period of 3 years. Do you understand?
Yes, sir.
Do you have any questions about what I've said so far?
Yes, sir.
And Mr. Merston, has your office filed a written intent to seek a proof evident presumptive rate hearing?
Not yet, Judge, but we will be following that. This case will be Mr. Walsh's and Ms. Harold's. They will get the attorneys listed on the, I believe, the most recent pleading from the defense.
Thank you. And I would point out, Mr. Watts, that the prosecution also indicated in the complaint and information that these were acts of domestic violence. Do you understand that?
Yes, sir.
Okay, thank you. And so, Mr. Walsh, what is your request today?
Your Honor, considering that we haven't received any discovery of the case, we're not in a good position at this point to advise the court about what kind of time we'll need. My suggestion to the court is that the court allow Mr. Watts to reserve the preliminary hearing in the case, reserve the proof evident hearing, and set the matter for a status conference about 60 days out.
So just to be clear, he is waiving his right to have a preliminary hearing within 35 days, that he's not seeking a proof evident presumption rate hearing prior to the setting of the status conference in about 60 days, but he's reserving his right to have those hearings in the future, but not necessarily within 35 days. Is that right?
Yes, Your Honor. We've spoken about those issues.
And do you understand what we're talking about, Mr. Watts?
Yes.
Do you have any questions about that? Okay. And Mr. Rourke, do you have any objection to that request?
No, Your Honor, that seems like the prudent way to proceed at this point.
Okay. Let me give you a date that, how does, so 60 days is about October 20th or so. I have October 11th. Does that date work for the parties? I can go a little bit further if you like as well.
I think a little bit further would make sense, Your Honor. Thank you.
How about November 19th? While we're waiting for lawyers to let me make a record that the court's going to find that Mr. Watts is knowingly, intelligently, and voluntarily waiving his right to have a preliminary hearing within 35 days. And while he has not asked for a proof of evident presumption grade hearing yet, I'm told that he will, and he's not requesting that hearing prior to the status conference that we're setting today. Agreed?
Yes. That date works fine with the defense, Your Honor. Thank you.
Your Honor, I spoke to the Rusiks, and that is fine with the people as well as the victims.
How is late morning on November 19th?
Anytime, Your Honor. Late morning is fine.
Very good.
How about 10:30?
That will work for the people.
And that will be in Division 16. I apologize for the bouncing around of division, but my courtroom obviously is not big enough, and I will keep you updated on where the divisions are going to be. But the next court date will be in Division 16. Are there any other questions, comments, concerns, anything that we can address today before us recessing?
I think there are a couple of things outstanding, Your Honor, and first I wanted to address one very ministerial point of clarification with respect to the standing decorum order that the court entered yesterday. By its terms, and when the court defines the applicable areas, that includes my office, so specifically the boundaries of the district attorney's office. I just wanted to make a request for clarification that the terms of this order do not apply to the conduct that occurs within my office itself.
Agreed.
Thank you. Otherwise, I have provided a copy of this to the employees of my office, and we will be providing it to law enforcement after this hearing is fine.
Thank you. I also intend on issuing a case management order later today, so be on the lookout for that.
I don't know if the court has the desire at this point this morning to address a couple of the other outstanding motions that the Public Defender's Office has filed that we had entered or filed responses to. We have not addressed motions 2, 3, 5, and 7. And those are the defense motions 2, 3, 5, and 7. And for the record, our responses were C, D, E, and F.
I don't have those motions in front of me, but I know that I issued a number of written orders yesterday. Did you receive those?
I received written orders, but not as it relates to those 4, so perhaps they just haven't reached my desk yet.
If they haven't yet, I will issue a written ruling. We'll be getting them shortly. But I issued a number of orders yesterday.
Your Honor, does that include, I did get the order on motion 5 and motion 7. Does that include motions 2 and 3 then that the court would?
Remind me what 2 and 3 are again?
Motion 2 is the motion to allow confidential defense experts to be present for any testing. And we did have a bit of additional argument on that if the court wanted to hear it. Motion 3 is a motion for a protective order.
I prefer that you put it in writing, and then I'll issue a written order with regard to that. Is that something that's time sensitive?
I think it could be, Your Honor. I can't speak for the district attorney, but it could be.
I can tell the court, understanding what Mr. Walsh is referring to in motion number 2, it is not something that is going to occur in the next day or 2, so it's not time sensitive in that respect.
So you'll be received, if you want to put something in writing, you're welcome to, and I will issue a written order in a timely manner.
Does the court want to give us a deadline for that?
Sure, when would you like to file a response?
I can have it done in a day or 2.
Okay. And so, do you have control, Mr. Rourke, as to when the testing is going to occur?
Absolutely. I can certainly make clear to our forensic agents that pending the litigation or the receipt of a court order on this, that we will not do any
So did you want to have time to file a reply to the response?
If necessary, if I could have 3 business days to file a response to whatever Mr. Walsh files in the next couple of days, I would appreciate that.
Okay, so Mr. Walsh, can you have something filed by close of business tomorrow?
Yes, sir.
Okay, so close of business on Monday, Mr. Work?
Yes, sir.
Then I'll have something to the parties by midweek next week.
Thank you.
Any other issues that we can resolve today?
Not for the people around.
No, Your Honor.
Okay. Okay, we are in recess. Thank you for your time.
So we've just been listening into the arraignment here of Christopher Watts. He is the man accused of killing his entire family, his wife, Shanann, his 2 daughters, Bella and Celeste. He is facing 5 counts of first-degree murder, 3 counts, of course, for the 3 people killed, but also 2 special counts of murder that have to do with the killing of a minor when you're in a position of trust. That's a particularly special charge there. He's also facing a charge for the unlawful termination of a pregnancy because his wife was 15 weeks pregnant with their son. You saw Christopher Watts' face. He was pretty stone-faced, difficult to read his emotions, and that really stands in stark contrast to the face and the emotions coming from Shanann's father, who was sitting there with his head down. It certainly looked as if he was crying or trying to hold back tears. You know, we watched Christopher Watts in front of the cameras make a desperate appeal for the return of his family. Now, what the prosecution is alleging is that he is responsible for their deaths, despite the fact that he told police officers that he did kill his wife, that he had told his wife that he wanted a separation because he was having an affair. And he says he killed his wife, but only in a fit of rage because after he informed her that he wanted to leave her, he said he witnessed her killing their 2 daughters. Clearly, the police and the prosecution are not buying that story because they charged him with the murders of all 3 of his family members, his 2 beautiful daughters and his wife, and also his soon-to-be-born son, Nico. All right, we're going to take a quick break from here. Of course, if there's any more information on this case and another case we are watching, Molly Tibbetts, her body has been discovered. When we get new information, we're going to bring that to you. For now, though, you are streaming CBSN.